Well, good morning, everybody, and welcome to the fourth in our series, the BDO series, targeted at the education sector. This is the second of my presentations in this series, and I'm going to speak this morning about the wonderful acronym known as NOCLAR, non-compliance with laws and regulations. So what's the background to this NOCLAR code? Well, you find it in APES 1110, which is a very long document and deals with the Code of Ethics for Professional Accountants. It's published by the Accounting Professional and Ethical Standards Board. There's a compiled version that you can find on the board's website as of September 2017. It contains both the NOCLAR provisions and, of course, other provisions that govern the conduct of accountants. Interestingly, but I'm not going to deal with it today, there are further changes that are mooted to APES 1110, arising from changes that have been raised by the International Standards Board, which the Accounting Professional and Ethical Standards Board has adopted, but is in the process of amending. It's very much a reorganisation of the code into a more logical and easier to read format, but there are also going to be some changes made to NOCLAR, and as I said, I'm not going to deal with them today. That will possibly be something we'll need to deal with at a later time once the draft amendments to the code become set in concrete. Now, as I said, NOCLAR is a wonderful acronym, and it simply means responding to non-compliance with laws and regulations. Why is the $64 question? Why has the APES Board and the International Standards Board bothered to introduce these new provisions? Well, a number of reasons that I've put there on the screen for you. Regulatory and enforcement authority concerns since 2007. I don't think I need to rehash the disasters of the GFC and the manner in which large financial institutions and small financial institutions behaved in an incredibly bad way, particularly in the accounting and auditing sector and oversight of what they were doing. We've had many situations pre-NOCLAR where auditors simply resigned due to identifying actual or suspected NOCLAR without actually addressing the issues. And the decision obviously was made that that wasn't really in anybody's interest. And then there was a lack of guidance in the code about the thought process and the risk factors that needed to be considered. So the code was empty. And the reason why we're spending such a lot of time talking about NOCLAR in the accounting profession is that it really is a monumental game changer for accountants. Auditors have had to live with having to audit for NOCLAR events for quite some time. They're very used to doing it. They know how to report it and what they have to do with it. But for everybody else who's in the accounting profession, it's never been a concern. So it's if you see something, there's really no obligation on you pre-NOCLAR to do any reporting, to take it up with anybody, unless, of course, you have belief in the integrity of your position, so you would do it out of want rather than legal requirement. But it's a game changer now because accountants can't simply ignore breaches of laws and regulations. They actually have to do something. So who is covered by NOCLAR? Well, we have all members of the CAANZ, CPA Australia and the Institute of Public Accountants are covered by it. So that's a fairly broad range of members there and would cover a lot of accountants that are around. Now, NOCLAR is broken up into 4 categories of accountants: auditors, other members in public practice, so that's obviously anybody who's not an auditor, the senior members in business, directors, CFOs, senior finance staff, and then other members in business. And for the purposes of today, we're going to focus on senior members in business and other members in business because those are the categories of accountants I would expect to find operating in the education sector. Now, NOCLAR, as I put there at the bottom, commenced on the 1st of January 2018, although it's certainly been under consideration for a lot longer than that. So what is NOCLAR? Well, you will see this definition mentioned in a number of places through the code, depending on what category of accountant we're talking about. But for the purposes of today, NOCLAR is acts of omission or commission, intentional or unintentional, committed by the member in business's employing organisation or by those charged with governance, by management or by other individuals working for or under the direction of the employing organisation, which are contrary to the prevailing laws or regulations. I know that's a bit of a mouthful, but that is the start of what is NOCLAR. I have to pause just for a second. Please bear with me. I'll be back in 1 second.
That'd been great.
Okay, I'm back. My apologies about that. There was just a bit of a technical hitch there for a second. Okay, so what's driving all of this? You may or may not know that the accountancy profession has at the forefront the mantra that it acts in the public interest. And as I've remarked to my accounting colleagues, lawyers are very differently placed. We don't have that obligation, although we have other duties, but we certainly don't have that one. And of course, it's always difficult to work out what acting in the public interest means. You'll see as I go through this, there's a bit of guidance in the code that tells you what that means. Now, members in business, when you conduct yourselves in your employment or in anything that you are doing in an accountancy sense, you have to comply with the fundamental principles of integrity and professional behaviour. Not that we would expect anybody to do otherwise, but regrettably sometimes that does happen. So it's stated there in the code. We have to enable management or those charged with governance to rectify, remediate or mitigate the consequences of NOCLAR or deter the commission of NOCLAR and take such further action as appropriate in the public interest. So there it is again, public interest. And as you can see, that really is a major change in terms of the obligations imposed on accountants who are members in business. That's never been there before. The focus of NOCLAR is on laws and regulations, as is obvious from the definition of what the acronym means, but it goes further than that in this sense. The NOCLAR has to have a direct effect on the determination of material amounts and disclosures in your employing organisation's financial statements and are fundamental to the employing organisation's operations, ability to continue its business or to avoid material penalties, and cause or may cause substantial harm to the wider public interest, including investors, creditors, employees, or the general public. So again, that is the focus when you're thinking about what does NOCLAR mean for me and my employer and the wider public interest. Now, obviously, a lot of employing organisations that occupy the education space, won't necessarily have investors, but they'll certainly have creditors, they'll have employees, the general public, obviously. A lot of the private educational institutions will clearly have investors, and that's probably where that comes in. But for the most part, if you're in a government department or a public school or a university and whatnot, not necessary that you'll have investors. Mind you, there are a lot of side companies that are set up these days, charitable foundations, special purpose vehicles for research and whatnot, where there are co-investors both from the private sector and government. So it's something you have to think about in terms of who am I responsible to in the broader sense of the word. Now, to continue the focus, we talked about substantial harm. So what is substantial harm? It's an act that causes substantial harm is one that results in serious adverse consequences for the above cohort of interests, and that's the investors, the creditors, the employees, the general public, in financial or non-financial terms. So once again, we're not just talking about finance, it's everything. And again, you can see some difficult judgment calls may need to be made from time to time in working through the process of, do I have a NOCLAR event? What am I meant to do with it? Now, thankfully, we don't have to worry about inconsequential matters, and that again has to be decided on a case-by-case basis. Clearly something that's not going to be material to financial interests or aren't going to resonate in any harm of any sort to anybody will be classified as an inconsequential matter. Further, NOCLAR is not concerned with personal misconduct. I just want to pause there. That, although that's the statement in the code, it may be different if in fact there are codes of conduct, policies and procedures that regulate, if I can use the expression, the inter-office romance, or those sorts of difficult workplace issues. They can resonate both in terms of breaches of internal policies. They may resonate in terms of breaches of the Fair Work Act if people are dismissed or for having romances and things of that sort. So although NOCLAR says not concerned with personal misconduct, in my understanding of it, certainly the way I interpret the code, there is that possibility that needs to be thought about. But quite clearly, when I talk about NOCLAR by third parties, that's very clear. You certainly do not have to worry about any NOCLAR that you might come across that is committed by a third party. So a third party is somebody obviously who's got nothing, is not part of your employer's organisation. So if you know that there is some breach of law or regulation being committed by, say, a supplier of goods or services to your organisation, that's not something you have to worry about. You don't have to report it to anybody, unless, of course, it's affecting, the provision of the services and goods. That's a different matter, but it's not considered to be a NOCLAR event. So what are these examples of NOCLAR? Now, the code lists what I've set out on the screen, and you can see it's a fairly broad range of examples. Not all of them will apply, obviously, in an education setting, but it just gives you an idea of the broad reach of NOCLAR. So fraud, corruption and bribery, that of course can happen in the education sector. Anti-money laundering and counter-terrorism financing, proceeds of crime, that may be more likely in the private education sector, not necessarily in public education sector, but you can't rule anything out these days. Certainly, I would have thought securities markets and trading wouldn't be something to worry about, or banking, financial products and services. Data protection, most definitely, and my first presentation in this series was all about that. Tax, pension liabilities and payments. Clearly, as accountants, that will be for at least some of you under your purview and what you might do on a day-to-day basis. Environment protection, that may or may not come into play. Public health and safety, I would have thought definitely, particularly if you're operating in a school or a university rather than a government department. And just to raise a couple of practical examples at this point in time, I'm sure some of you will recall that we've had in relatively recent times an education department bureaucrat who was accused of stealing millions of dollars that had been set aside for state schools. And that person was investigated by the Victorian Independent Broad-Based Anti-Corruption Commission. And we were talking about at least $2 million in funds having been channeled by that bureaucrat to relatives and associates. Clearly under NOCLAR, if you were aware that something of that sort was happening, that would fall into fraud, bribery, corruption, and you would report it. And then there were two other examples that I'm aware of where the ACCC firstly was involved in taking action against a private educational institution for unconscionable conduct. The conduct there was misleading and deceptive statements and representations being made by a private college to induce students to sign up and pay money to them. And on the basis of that, getting money from the government based on the number of students and what have you. And the ACCC called for a repayment of $106 million to the government in that case. And then there was another private college scandal where we were talking about $160 million in government funding had been obtained based on false and misleading representations to get students to enrol and to sign them up to a government loan scheme. So these sorts of things are obviously nefarious. They do happen in the education sector, and as an accountant, now if you are aware of any of this sort of thing, you can't ignore it. You're going to have to deal with it. You may be all sitting there thinking, but we're not lawyers, we're not policemen, we're not detectives, you know, isn't this a bit much? I will come to that on one of the later slides. So what do I have to do? What do I have to do if I know about NOCLAR? So for members in business, you have to act on a timely basis, having regard to your understanding of the NOCLAR event and the potential harm to the interests of the employing organisation, investors, creditors, employees, or the general public. Now, you'll notice there that it doesn't talk about students, but I think you could definitely argue that students fall within the concept of general public. And interestingly, the code provides a definition of what a member in business is, and I'll just read that to you. As a member employed or engaged in an executive or non-executive capacity in such areas as commerce, industry, service, the public sector, education, the not-for-profit sector, regulatory bodies or professional bodies, or a member contracted by such entities. So the code clearly identifies the education sector as a key sector that members in business operate in. And that's why I think the mere fact that students are not mentioned in the definitions of interest groups is probably just by the by. Now, because of the position occupied by senior members in business, and remember we were talking about CFOs, directors, and the like, the code places a greater expectation on them to act in the face of NOCLAR than other members in business in the employing organisation. That's a bit of a bald statement that the code has. It doesn't actually go on and explain that further, but you get the sense of what the greater expectation is when you read through the code and see what senior members in business are meant to do when faced with a NOCLAR event. Now, for both categories of members, they're expected to apply their knowledge, their professional judgment and expertise, but are not, and I've highlighted are not, required to have a level of understanding of laws and regulations beyond their role in the employing organisation. So that addresses the issue of, hey, I'm not a lawyer, I'm not a policeman, I'm not a detective. How the hell am I meant to handle all of this? You don't have to know everything that might be relevant to your employer's activities. You just have to have a level of understanding. So it's not even necessarily an expert level of understanding, but a basic level of understanding of the laws and regulations that are relevant to the role that you are playing. So this is the general framework of the things that you're meant to do as a member of a business. There's a process that has to be followed, and I'm going to outline what that process is for you in the following slides. So NOCLAR firstly says you've got to obtain an understanding of the matter. So consider the nature of the act and circumstances in which the NOCLAR has occurred. You should consider the application of relevant laws and regulations to the circumstances, and you have to consider the potential consequences to the employing organisation and those cohort of interests that I spoke about. Now, I should say, sorry, just before I move off that slide, unfortunately, the code does not provide us with any outline of what these considerations actually entail. But again, so much of what this NOCLAR is about is judgment call. So it's very much judgment call, judgment call, judgment call, based on the facts and circumstances that you confront at any given moment. The next step you have to take is addressing the matter. So for a member in business, there's not a lot you have to do. And as you can see, the first thing you do is advise your immediate superior that you think there's a NOCLAR event. However, if the immediate superior appears to be involved, you go to the next level of authority. And you keep doing that because it may well be that there's a number of people in your chain of command, so to speak, who might be involved in a NOCLAR event. And you've got to find someone who you believe isn't involved. And at the end of the day, you may well have to go all the way up to the top, namely those charged with governance. If they're all involved, then you've got a real problem, which I'll talk to you about in a minute. For the senior member in business, however, there's a lot more that that person has to do, and they have to do the following. They have to communicate with those charged with governance to take appropriate action. They have to comply with the applicable laws and regulations and any legal or regulatory reporting obligations. Have to rectify, remediate, or mitigate the consequences of the NOCLAR. They have to reduce the risk of reoccurrence and seek to deter the commission of the non-compliance if it has not yet occurred. Now that's a really big menu of things that have to be done by the senior member in business. But again, recall that it's qualified by take appropriate steps. Sometimes you're not going to be able to fix some of these things, obviously. Communicating with those charged with governance and telling them they've got to take appropriate action, that's not going to be difficult. Actually complying with applicable laws and regulations, obviously if you're getting pushback or refusal to act, and that's not out of the question, that's going to present a difficulty. If there are no legal or regulatory reporting obligations, then obviously you can't comply with that. And remember, in terms of ordinary crime, there's very little reporting obligations that are placed on individuals to go to the police or any other authorities if in fact you're not an auditor. Rectify, remediate or mitigate the consequences of the NOCLAR. Well, again, that may or may not be possible depending on the breach in question. So, for instance, if there's been a fraud and money has been misappropriated, it's going to be very difficult to get it back in most cases. But again, that's something I think everybody would accept would be reported to the police. Reducing the risk of reoccurrence, well, that is something that can be attended to. It really is a matter of looking at how did something happen that is a NOCLAR, what do you have to do to fix it, how do you prevent it from happening again, and of course in the anticipated NOCLAR, then if it hasn't already happened, you've got to take whatever steps are reasonably practical to stop it from happening. So you're a senior member in business, you've done all of those things. Is that enough? No. Well, the code says no, and it says you've got to think about, is there anything further you need to do? So this is what you have to go through as step number 3. So you've spoken to superiors, you've spoken to those charged with governance. They've either said, don't worry about it, it's not a problem, or they've said, oh my goodness, we've got to deal with this issue, this is what we're going to do. You've got to assess the appropriateness of the response you get. You can't just say, I told them, they said they'd get onto it, and I can walk away now because I don't have any further responsibility. It's not how it works. You then need to determine if further action is needed in the public interest, okay? So it's not just about your employing organisation. It's again this, what I call the dreaded public interest. And the code says in determining what might need to be done to protect the public interest, you've got to look at this: the legal and regulatory framework, the urgency of the matter, how pervasive the matter is through the organisation. Obviously that means, is it rife, or is it just an isolated event, or somewhere in between? You have to make a judgment call about whether you have confidence in the integrity of your superiors and those charged with governance, and that of course can be a very difficult thing to have to grapple with. You have to decide whether the actual or the suspected non-compliance is likely to reoccur, and you have to decide whether there's credible evidence of actual or potential substantial harm to the employing organisation or the cohort of interests. Now, I can see some of you thinking, not really, I can't see anybody, but I can see some of you thinking, you just told me I don't have to be a lawyer or a policeman or a detective, and I only have to know the laws and regulations that sort of are relevant to my job. But now, on this limb of the steps I have to take, I have to look at the legal and regulatory framework. So what I'd say to you there is, though, it really is, again, within the context of what you understand, what you know, it's not really obliging you to do something altogether different. That is, go and look at a legal and regulatory framework that is much broader than what your area of expertise, position description, or the like is concerned with. So there's a lot of work there that a senior member has to do. But we can't stop there. The senior member then, having done all of these things and having considered their position, then has to stand back and judge their actions by saying, well, let me take myself out of the situation here and say, would a reasonable and informed third party say, yes, I think that person acted appropriately in the public interest? Now, again, that's a difficult exercise to achieve. It's very much what I'd call a sort of lawyer's concept, because we love to talk about assessing people's conduct against the reasonable man in the street test. And that's very much that kind of context in which that has to be considered. But I would very much encourage people to step back, have a look at what they did and said, if this appeared on the front page of the Herald Sun or somewhere like that, how would that go down? Would people think I'd done the right thing, or would they call my conduct into question and say I've fallen short? There are other steps that the code says you can take if you're not satisfied with where you've reached, and that is obviously in corporate groups. So if your employing organisation happens to be a member of a corporate group, and again, clearly that's probably going to be more relevant to private organisations than any other, then the senior member may consider reporting it to the management of the parent entity. And you'd probably only do that if, in fact, having gone through the steps that we talked about, you felt that you didn't have confidence in the integrity of your superiors or those charged with governance. If there's an outside management team in a parent entity, you might feel that's the best way to go and to report to them. The next alternative is reporting to an appropriate authority. And we'll talk about appropriate authority in a moment. And then, of course, I'm not being funny here, the code actually does put this in. It says resign. At the end of the day, if things are so pervasive and uncomfortable and illegal, if you like, then that resignation is an option. But the kicker on that, unfortunately, is that even if you think about resigning, you've still got to go through all the obligations that are imposed upon you by the code. It's not a get out of jail free card, resignations. Now, having gone through all of that, the code also says, look, it's all right for both categories of members for you to consult internally, get legal advice, or consult confidentially with a regulator or a professional body. Now, from a practical point of view, yes, it's easy enough to go and consult internally, speak to a trusted colleague or mentor or someone in that capacity. Obtaining legal advice, I think, is a bit more difficult because obviously the organisation, if you want to get external legal advice, which you may think is appropriate, we all know that the organisation is not going to be paying for it, so it's a bit of an imposition to expect you to, as an individual, to go and get legal advice about something and have to pay for it yourself. It's certainly a problem that whistleblowers have faced from time to time. Consulting confidentially with a regulator can be sometimes problematic because they're really more used to dealing with things in an official capacity rather than, come and have a chat with me and we'll see if there's something we can do to help you. Although, if, for instance, there's something that you would have to report to the Australian Securities and Investments Commission, which could be an appropriate regulator in a particular situation, they have a whistleblower policy. Again, if it's the Australian Taxation Office, there are methods with which you can communicate with them in a confidential basis. So you have to be careful with all of that if you are faced with that option. And then, of course, professional body. And professional body may be an option, but I'm not yet convinced that everybody's really set up to deal with advice on a confidential basis. And we're talking again about your professional bodies, the CAA, NZ, CPA, etc. But no doubt, as time goes by, they will get more experience with this, and instances of NOCLAR come up. People get more comfortable with understanding how to deal with this. So, as I said, we get to it, disclosure to an appropriate authority. So is the disclosure precluded by law or regulation? And that's the first question that needs to be asked here, because the code specifically says you are not obliged, and in fact, really you're not permitted to make a disclosure to an appropriate authority if in fact there is a law or a regulation that says you can't. Okay. So that's the first thing you need to know and to determine. Next is, what is the nature and extent of the actual or potential harm? So what are we talking about? Is it really something that you have to report to an appropriate authority? Can it be dealt with through all the processes we've just gone through? Or even if you don't get to a satisfactory outcome, is it so serious a harm that it needs to be reported to an appropriate authority? Then think about, are there external factors that might apply? So firstly, is there an appropriate authority? Now, I know the code asks that question. I think the answer to that is there's almost always going to be an appropriate authority for every particular instance. So, you've got ASIC, you've got the ATO, you've got police and fraud squads, you've got WorkSafe, you've got the Fair Work Ombudsman, you've got the Environmental Protection Authority, and so on and on and on it goes. It'd be very hard to find a situation where there is a breach of the law that hasn't got an appropriate authority for you to report to. And then the other thing that you need to consider is, if I'm making a report to an appropriate authority, is there protection for me from civil, criminal, or professional liability or retaliation? Retaliation or victimization is a big thing, and things that people need to think about if, in effect, they're going to be a whistleblower. So I've said there, for instance, is there effective in place whistleblowing legislation that you could report to an appropriate authority under and gain the appropriate protections for your actions? Now, the other thing, and obviously most importantly, that you need to think about is, have you been threatened? Are you concerned for your physical safety if in fact you take a step to report? Thankfully, I don't think those things happen on a regular basis, but I'm sure that it can't be ruled out, and it may well occur from time to time. So at the end of the day, if you think that reporting to an appropriate authority is going to put your physical safety at risk, then you don't have to do it. So now we come to the scenario of actually making a disclosure. If having gone through all of this, you think that disclosure is considered to be appropriate, then for the first time, the code now says this will not breach the duty of confidentiality under section 140 of the code. And for those of you who don't live with your codes like I do, or don't have it in front of you, I just want to take a few minutes to read you section 140, so you get a feel for what it says. 140.1, the principle of confidentiality imposes an obligation on all members to refrain from disclosing outside the firm or employing organisation confidential information acquired as a result of professional and business relationships without proper and specific authority, or unless there is a legal or professional right or duty to disclose, and using confidential information acquired as a result of professional and business relationships to their personal advantage or the advantage of third parties. Probably that second limb won't apply, but the first one certainly would under normal circumstances, but for what I just read you about NOCLAR. 140.2, a member shall maintain confidentiality, including in a social environment, being alert to the possibility of inadvertent disclosure, particularly to a close business associate or a close or immediate family member. Let me go on. I'm just going to jump around a bit here. A member shall take reasonable steps to ensure that staff under the member's control and persons from whom advice and assistance is obtained respect the member's duty of confidentiality. The need to comply with the principle of confidentiality continues even after the end of relationships between a member and a client or employer. When a member changes employment, the member is entitled to use prior experience. The member shall not, however, use or disclose any confidential information, etc. I think you're probably getting the point of this. And then 140.7, as a fundamental principle, confidentiality serves the public interest. There it is again, public interest, because it facilitates the free flow of information from the member's client or employing organisation to the member. Nevertheless, the following are circumstances where members are or may be required to disclose confidential information, or when such disclosure may be appropriate. Then it talks about being authorised by law, having to produce documents under compulsion, and so on and so forth. And we're talking about NOCLAR. It says one of the provisions are to comply with technical and professional standards, including ethical requirements. And I'll stop there. There's more to 140 than that, but you'll see we start with the prohibition on breaching confidentiality, and then have a carve out for compliance with professional standards. We didn't have anything by way of professional standards before NOCLAR that would have allowed you to report to an appropriate authority, but we do now. Then moving to the second dot point there on the page. Now, obviously, there may be scenarios where there's an emergency or an urgency where action has to be taken because there's going to be an imminent breach of a law or regulation that would cause substantial harm. What do you do there? Well, you don't have to go through all the steps that I set out in these slides. You don't have to discuss it with management or those charged with government or your superiors or anything like that. If you feel, obviously acting in good faith and reasonably, that there is an emergency situation, you can act. And that also will not constitute a breach of the duty of confidentiality under section 140 of the code. Now, when you actually act using this carve out, the code specifically says you do have to act in good faith and you have to, let's say, not gild the lily in the statements you make when you report to the appropriate authority. Not that I suspect you would in any event, but that's what the code says. Now, documentation is the last step that we need to talk about, and obviously for auditors, they would appreciate the need for documentation because everything they do has to be documented under various auditing standards because they get reviewed from time to time by the regulator, and if the files aren't in order, that can lead to significant consequences. For the ordinary accountant, and I don't mean that disrespectfully, I should say the non-auditor accountant, probably don't engage in documentation quite to the same extent. There may not necessarily be a need for it. But when you're in the NOCLAR area, let me encourage you to scrupulously follow, for your own protection, if for nothing else, documenting everything surrounding the NOCLAR event and what you do with it. And what the code specifically says is, it says you're encouraged to document. My advice to you is to do more than just think about being encouraged, but actually do it. Because there's nothing that gives you more protection if there's a blowback or some follow-on from what you've done than good notes, good records, and made contemporaneously if you can achieve that outcome. So what should you document? Obviously the matter, what is the NOCLAR event, what we're dealing with, discussions with superiors, if there are any, or those charged with governance, or anybody else for that matter. So, how do you record discussions? Forgive me for sounding like a lawyer, which of course is what I am, but, you put down times, dates, places where you had the discussions, who was present, how long did the meetings last, and as best as you can, what matters were discussed, who said what to whom, that sort of thing. Next, the response to the matter. Well, if you follow what I just said, obviously you will record what the responses were. Very important to get that down. And then finally, document what courses of action were considered as to how to deal with it, what judgments were made, and what decisions were taken. Again, applying the reasonable third-party test. So that, just to remind you, refresh the scenario, it's what would the third party sitting next to me, not knowing me, think about how did we handle all of this, how did I handle all of this if I'm confronted with a NOCLAR event. Now, I just want to deal with a couple of scenarios where laws and regulations may come into existence that prevent you from reporting to an appropriate authority, and there are two that are quite common. The first one I wanted to deal with is the confidentiality agreement. So if you've signed a confidentiality agreement or a non-disclosure agreement, or you have such clauses in your employment agreement, which is very common, does that prevent you from disclosing? Now, my answer to that question is I believe it does. And if you, and I've just quoted there for you the International Standards Board's guidance in relation to NOCLAR. They've published a number of staff questions and answers. Question 6 dealt with the recognition of this tension between confidentiality clauses and compliance with professional standards, and the applicable laws and regulations all in the same document. So it's very difficult if you're an employee and on the one hand you're obliged to keep things confidential, and on the other hand obliged to behave in a professional manner and in accordance with your professional obligations under standards that govern your job. There's an impossible tension there, but in the way those documents might be drafted, but the answer I give you is, notwithstanding that, I think the answer is clear. You cannot disclose to an appropriate authority if you're bound by confidentiality. You may decide, well, I'm going to be a whistleblower and I don't care because I'm so concerned about what's going on, and I'll take the consequences of breaching the confidentiality obligation. That's fine. That's another step. But a confidentiality clause or obligation is a law or regulation in the context of laws or regulations under NOCLAR. You might be aware, and it was interesting that I believe it was the Commonwealth Bank released all of their employees from their confidentiality obligations, their employment agreement, so that they could make submissions or give evidence to the Banking Royal Commission. Otherwise, they would have been prevented from it. And Commissioner Hayne was pretty clear that, you know, if any of the financial institutions prevented their employees from giving evidence or making submissions because of confidentiality clauses, he would have something to say about it. So that reinforces what I'm saying. So again, if disclosure is prohibited because you're bound by confidentiality, you still have to take all other steps in the NOCLAR process, notwithstanding that. All right? The only step you can't take is a report to an appropriate authority. And then for those of you who are in the tax field, the Tax Agents Service Act, no doubt you're familiar with it. It covers registered tax agents, BAS agents, and tax advisors. It contains within it a code of professional conduct, and subsection 3010(6) within the code says, unless you have a legal duty to do so, you must not disclose any information relating to a client's affairs to a third party without your client's permission. Now, it's given a broad guidance on the meaning of client's affairs, and it talks about really anything to do with the client's affairs, anything at all. Now, of course, there's an issue, well, I'm employed, is that my client, is it not my client? I'm not in private practice. But as I understand it, the way the TPB interprets it, they interpret it very, very, very widely. So even if you, as a tax agent, for instance, knew that, let's say, a fraud was being committed by a client, you can't say anything about it. Or they were breaching the Corporations Act, you can't say anything about it on the basis of the TPB's guidance. So that's very broad too. But again, if disclosure is prohibited, you're caught up in that because you're a tax agent, etc., then all other steps must be taken by you to deal with a NOCLAR event. And I note the proposed whistleblower legislation. I've had a look at that. It was meant to come in on the 1st of July. It's obviously not coming in on the 1st of July because we've passed that date. Hasn't yet been formally considered by Parliament, in the sense that the Senate, there was a Senate committee that looked at it, made certain recommendations, hasn't yet come back to Parliament for implementation. There is a tax carve-out for whistleblowing within this legislation, but I don't see that it really contemplates tax agents using the whistleblower legislation to report on NOCLAR to an appropriate authority. Rather, it seems to suggest that people can make whistleblowing and comments to tax agents, but that's something we'll have to work through once the legislation is in final form. So just to round up and finish off, we're 5 minutes to midday. Just a couple of practical tips and questions for you to think about. I urge everybody to read and understand the code. There relevant sections. It's not hard to read, and there's not a lot there to read, but it really is worth taking 15 minutes to go through it, just to refresh yourself or understand what it says. Look at the code through a risk prism. It's not just more red tape. I know everybody thinks we're already inundated with obligations and what have you, and I certainly appreciate that comment, but it really is a risk prism, and you should look at it that way. Understand the regulatory framework in which your organisation operates, if you're not already, of course, but you know, it's always good to stand back, have a think about, well, what are the laws and regulations that apply to what I'm doing. If you are a superior, supervisor, or have staff underneath you, then provide training. Talk to them about this because it applies to everyone who's a member in business. It's not just an individual thing. Implement and update policies and procedures to deal with this. If you don't already have a whistleblower procedure in your organisation, you might consider or recommending that one be adopted. Know whether you are bound by a written confidentiality obligation or not, so you know what you need to do or can't do if confronted with NOCLAR. Have a think about when you might seek legal advice, and if you need to, how you're going to handle it. And then finally, do you know who the appropriate authority is? Be prepared. If in fact you're allowed to report, have a think in terms of your job, who's the appropriate authority. And that's the end of my session for today, with 3 minutes to spare. Let me thank you all for attending and listening to this presentation. If you have any questions or would like to follow up, then by all means get in touch with me, either by telephone or email. And otherwise, thank you very much for listening and have a good day.